Good afternoon, honorable members. When we suspended for lunch, we were debating the bill for an act to incorporate the agreement granting legal status to the International Development Law Organization into the laws of the Bahamas for connected purposes. I presume you're ready to begin, as many. The chair recognizes the honorable member for East Grand Bahama.
Yes, Mr. Deputy, I just wanted to get a copy of the bill. Thank you. Mr. Deputy, thank you. And again, it's a privilege to be able to speak on behalf of the good and special people of the East Grand Bahama constituency. And Mr. Deputy, I do not intend on speaking very long in reference to this bill. Let me just say that the caucus on our side has looked at the bill. There are two issues that I will raise, but we do not intend on, unless those two issues are dealt with, we do not intend on supporting the bill. The first issue, Mr. Deputy, is, I believe, Section 5 of the bill, which speaks to the minister may amend the schedule. The difficulty, I believe, that we have with this is we have a difficulty in the minister being able to amend the schedule without parliamentary approval. So my understanding of Section 5 is that if the agreement is changed, then the minister has the ability to amend the schedule, which is the agreement. The minister would have the ability to amend the schedule without coming back to Parliament to get parliamentary approval to amend the schedule. Again, my understanding is Section 5, right? The bill brings into law the agreement. The agreement is articulated in the schedule. My understanding of Section 5 is that if the schedule is changed, or if the agreement is changed, the minister has the ability to amend the schedule without coming back to Parliament and getting Parliament to agree to it. So our difficulty is we believe that the minister should be able to come back to Parliament, and in order for it to be made law, the same way that we are coming to Parliament today, and the schedule is being made law today as a result of Parliament, he has to lay it on the table. But our difficulty is that we believe that he should come back in the same way he is coming today with a bill and presenting that to Parliament, and then there is a debate on it, and then there is an agreement with respect to it. Sure.
The chair recognizes the honorable member for Cat Island, Rumkey, and San Salvador.
I'm sure you're aware of section, right? Regulations, other orders are made in this, made here by ministers on a regular basis, right? Without reference to Parliament when it's made. It then comes and it's laid on the table, laid here in the House. And there's a mechanism to have it either debated and or reversed and or annulled, settled in the general, in section 32, I think, of the General Clauses in Interpretation Act, which requires that if the amendment is made, because your concern is it might be an amendment that you may not agree with.
Correct.
Well, if you don't agree with it, when it's laid, you have you have 6 weeks in which to lodge your complaint and have it debated to put your point across. That's no different than if I come here first and do it. That's just a convenient process to have it done. It's laid on the table, and if you have any issue, you could raise it. So it's a non-starter, in my view, in respect to that complaint. You still will have the opportunity to debate it, to make your views known about any amendments, and perhaps be able to persuade colleagues in here to your point of view to have that amendment annulled.
Again, Prime Minister, I do understand. Thank you. I do understand your point in terms of that. My view is it shifts the burden on us to do something. My view is it shifts the burden on whoever is in opposition at that time to make the point. But again, it is my view that if the government makes an agreement and that agreement should be made law, then the same manner that you are bringing it here today, where there is a bill and that bill is debated and that bill is agreed, then it is my view that that should be the same. That is our view, that the same process should be put into place.
I understand your view, but I'm trying to have you see it in the context of the practicalities of nature of things. Because what you're saying to me is that if this is your position in respect to this, then every order, any regulation that is to be laid by a member, because many legislation, many laws that are passed in here gives a minister the power to amend, make regulations, etc. So before they do that, they should come to Parliament? Is that your point of view? And if it is, we'll have to. But that's what we've been doing from time immemorial. That's why Section 32 is put into the General Clauses Interpretation Act, so that if you have some issue with what the minister would have done, you could then raise it within 6 weeks and have it done. I mean,
again,
we say you're putting a burden on you. It's not a burden. All you have to do is be vigilant. It's your job. Because if you feel strongly about anything, you should get up and say, as you're saying now,
yes,
you feel strongly about this, right?
Yes.
But I'm pointing out to you, I hope I persuade you that it's a non-starter because of the process in our legislative making powers.
So, again, thank you, Prime Minister. I'm not persuaded, unfortunately. I can't speak to the other orders and what has happened with respect to the other orders, but because this is the bill that is in front of us now that we are debating. And so, again, with respect to Section 5, we on this side have a difficulty with agreeing to Section 5. I believe it would be helpful if we put Parliament and replaced Minister with Parliament, and that way, if there is a change, there may never be a change to this agreement. But if there is a change, then in order for it to become law, then you would have to come back through the same process. So we would have a difficulty in supporting Section 5. The other point, very quickly, Mr. Deputy, is under what we understand this bill to do is the bill is to incorporate Articles 1 through Article 21. It incorporates Article 1 through Article 21 into Bahamian law. And to my understanding, I may be stand corrected, but to my understanding, there is no place in Bahamian law that grants rights to, equal to a spouse, that grants rights to a domestic partner. And so, which article that was, no? 12.3. Right. Under Article 12.3, under Article 12.3, it says the family members forming part of households of officials, except for those family members forming part of the households who are nationals or permanent residents of the host country, shall be accorded the same privileges, immunities, and facilities accorded to officials pursuant to paragraph 1 of this article. Such spouses and domestic partners of officials shall also be able to apply for work permits upon request for the duration and employment of the official with the IDLO in the host country. So in essence, what I understand is this bill is granting certain rights equal to the spouse's rights to domestic partners. And as far as I'm aware, that may be the first time that you are granting rights to a domestic partner. And so I'll be done in 2 minutes. And so our difficulty is this may have implications to a broader question. And I'm not prepared, and we on this side are not prepared to support this until there is a broader consultation on that issue. And so we on this side are not prepared to support it for the first reason. We believe that it should be changed from minister to parliament. And the second reason is that we understand that this bill introduces rights equal to a spouse to a domestic partner. And until there is a broader discussion on this point, we are not prepared to support it.
Thank you, Honorable Member. That's many. The chair recognizes the Honorable Member for Freetown.
Mr. Deputy Speaker, again, I rise on the good graces of the Lord and the people of Freetown to be very brief on this bill, as the side opposite have only flagged up 2 issues. Why y'all trying to provoke problems?
You didn't give him a job, man.
Mr. Deputy Speaker, the 2 points raised, in my humble view and submission, doesn't impact the important work that this body does and will continue to do in assisting us to address the scourge of crime in this country. This body assists in the training of prosecutors, and so that is a matter of a skill that we need. But from where I stand as leader of government business in the House, scheduling time for debate in terms of the calendar is of some substance. The point is taken that we could very well come back and seek to amend the act, but the member for Cat Island, Rumkey, and San Salvador has made the powerful point that if that is something that is desired in any particular case on the initiation, we would then have to find time to debate it. As it stands, this act does what just about every other act does and permits the minister to lay an order which is still subject to parliamentary oversight and control pursuant to Section 32 of the Interpretation and General Clauses Act. And so any party, backbencher or the opposition will have their say. I do not agree with East Grand Bahama that this is the first time that we will be recognizing or according rights, if that is how it's to be described, to domestic partners. We have recently done just that, Mr. Deputy Speaker, in I think this very same term, when, or certainly the one before, when we enacted the Protection Against Violence Act, because domestic relationships which are protected from violence, which create a right that is enforceable according to the terms of that act, are set out in Section 2 of the Act. And it says this: domestic relationship means a relationship between one or more persons. Curiously, it would be more than two. I'm just saying, Mr. Deputy Speaker. It says between one or more persons, which could be more than two, who are, who, A. What?
For you to point that out.
I didn't draft the bill, Mr. Deputy Speaker. I should say, aside, Mr. Deputy Speaker, that the curiosity in the sister country, Canada, is you can register up to 6 parents on a birth certificate. Curiously, there's a legal reason for that that we ought not to delve into now. But paragraph A provides these one or more persons who are or were married to each other, either under any law, custom, or religion. So that's the present tense and the past tense, who cohabit together. And there is a surprising number of Bahamians in couples who meet paragraph B as opposed to paragraph A. And then paragraph C are one or more persons who are engaged, courting, or in an actual or perceived romantic, intimate, cordial, or sexual relationship of any duration. D, are parents of a child or are expecting a child together or are foster parents to a child. E, are family members related by consanguinity, affinity, or adoption. F, are living together as spouses although they are not married. G, share or shared the same household, again, present and past tense. H, are co-tenants. I, is a house help in the household of the other. J, lives in or attends a public or private care institution and is under the care and control of the other person. K, is in a relationship as determined by the court to be a domestic relationship. We have accorded those persons rights, quite extensive rights of a very significant nature to be protected from violence and to be able to move the court in accordance with the Protection Against Violence Act. For all that was raised on this debate in this place and in the society, because there was much talk about it, my predecessor in the office of Leader of Government Business was alive to engage with the allegation of no consultation, changes, all of that. And there was engagement even after this was presented and debated. No one has ever complained that I am aware of as to the definition of domestic relationship to which we recognize and accord substantial rights. The reality of this organization is that the immunities granted relate as they do with any sovereign country to their circumstances. In our country, we already recognize domestic relationships. We already protect them and accord them rights. We may not agree with them, but we do recognize and accord them rights. And so, Mr. Deputy Speaker, the support that this organization brings is very real to our prosecutors and judicial system. There's nothing unusual about the agreement. There is nothing unusual about a minister being able to lay an order that affects the content of an act, subject to Parliament having the ability to annul that decision if any persons raise an issue under Section 23 of the Interpretation and General Clauses Act. And so, Mr. Deputy Speaker, Freetown supports this bill.
Thank you, Honourable Member. As many, the Chair recognizes the Honourable Member for St. Albans.
Mr. Deputy Speaker, I second the comments made by my colleague from East Grand, Bahama. And I notice that we're looking at this as though we shouldn't do anything for this one because we haven't done anything for the prior ones. And Mr. Deputy Speaker, it would be my argument that we haven't done anything for the prior ones because there wasn't any issue with the prior ones. And there's an issue that's been raised today with this one. So while we don't want to slow down the train on all the other treaties and all the other treaties and prior agreements, there's no reason why we can't make an exception here. So when this agreement ever has amendment, it doesn't simply go to government, but it goes to Parliament. You can keep the 100 where no issue is raised, but let's allow the people to have this one come through Parliament. Now, there was an entertaining description of domestic relationships given, but the word that is at issue, the term that is at issue is domestic partner under this agreement, Mr. Deputy Speaker, not domestic relationships. So we can't simply say that domestic partner has been discussed and approved without issue when we've never discussed domestic partner before. All we've discussed is domestic relationship. This issue has been identified by the opposition, and request has been made, Mr. Deputy Speaker, for there to be exceptions, that we approve it beforehand rather than make representations to the international community and say this amendment has been agreed upon, only to go back to them 6 weeks after the fact. It probably would be more because you have 6 weeks within which to give notice. And based on the agenda, we have some pieces of legislation in 2024 that have been on the agenda from 2023. So you could be a government that has a public image, that has approved something, said they're going to amend it, given everybody the understanding that they have amended it, only to come back to them 6 weeks, 7 weeks, 7 months later to say, in fact, what we gave a representation we did agree upon. Parliament has now negated that, and we can't agree upon it again. We've identified a problem here. We didn't have issues with the ones prior. This is the prime opportunity to take into consideration the points raised by East Grand Bahama and allow the proposed amendments to go through. And even in this case, I think, as East Grand Bahama has said, leave this bill in committee, take it for public consultation. Just to conclude, I'm going to confirm domestic relationship may have been a definition that came through this House of Assembly in August of 2023, but we're now talking about spouse and domestic partner. Thank you, Mr. Deputy Speaker.
Thank you, Honourable Member. As many. The Chair recognizes the Honourable Member for Fox Hill.
Right. This is the end. Yep. Yeah. That's why I asked if anybody else was going to say anything. No, you're done? So, thank you, Mr. Deputy Speaker, and I want to thank all members for elucidating the points they've raised with regard to this. And it is obvious we have a policy difference between the opposition and ourselves on the bill and its provisions. I'd like to reduce it, though, to its simplest form, which is that upon independence in 1973, the Bahamas government, qua the cabinet, has the responsibility for the negotiation of agreements and treaties between countries. And so last year, in pursuance of that, the agreement was settled and signed on the 8th of May, 2023. The agreement is signed pursuant to a prior agreement we have, which we succeeded to, called the Vienna Convention on Diplomatic Relations, which was supported, which was accepted by the British on our behalf in 1961. And we have followed those provisions. And as I indicated when I was speaking in moving the bill, that these apply to diplomatic immunities, the inviolability of premises, of the persons, of the individuals, of their property, of money. They are immune from suit. They have a juridical personality. They can execute leases, but again, they can't be brought before the civil courts. So all of these immunities arise. And so in connection with the paragraph 12.3 of the agreement, that's settled, and we are simply following in the footsteps of the Vienna Convention on Diplomatic Relations. We already, as a practice, accept, by reasons of comity, the provision with other states who have requested this kind of reciprocity. So we see nothing unusual in that sense. The question is then whether or not there's anything unusual about the provision which calls for a minister to be able to amend the schedule. As been pointed out here by members who spoke before me and by the Honorable Prime Minister, this again is not an unusual provision. And I was indicating to him that there is, in fact, as he pointed out, the clause, the section in the Interpretation of General Clauses Act, which gives you the authority as a member of Parliament to put, when it comes to notices, for example, when this bill becomes law, and there's a change, if there's a change in the schedule, it's gazetted, it has to be laid here. Within 6 weeks of your laying it here, any member can just, and you don't have to wait till the House of Assembly meets, because you can also give notice by writing the Speaker and saying at the next meeting of the Parliament, once it's 24 hours ahead, I'd like to put this on the order paper. So it's done. And I've done it because when the central bank in the last term decided in their wisdom or lack thereof to abolish the penny, we brought a resolution in the Senate to reverse the decision. So I know it can be done. So there's nothing unusual about that. My recollection is that usually the Parliament only uses that positive resolution that you're talking about, or that positive kind of approval, when there's some tax issue involved or some money implications. So, for example, if you're imposing a tax through regulation, it's been the practice. Certainly, I remember it mainly in Hubert Ingram's governments that you would come back here and say, if you're I know the obvious example is if we're changing parliamentary salaries. There's an order done, and then I think you have to come back here, and that has to be positively approved. Well, that's the tax implication, so the Parliament is asked to do that in advance. But generally speaking, with most orders, They're just done by regulation and gazetted, and that provision is made available. This is also, of course, an example, I think, of when the Prime Minister made the point about we are leaders in here. And I'm always, as I was saying during the debate on immigration, there's certain things I believe, and my experience has taught me as a parliamentarian, is that you can either be a delegate, which you are in some senses, or in other senses, you are the principal. And you have to make a decision in your discretion, your, what is this expression from the Parliament? In your own deliberate judgment. In your own deliberate judgment. Which are you at what time? Are you a delegate or are you the principal? And in this case, I think this is one of the situations where you're the principal. And you have to say, instead of raising problems about this in public, treat this as a matter of routine. And you can explain it because it's on all fours with the law. It only applies to the persons who are subject to this agreement. It does not apply to people in the domestic theater because those rights are not yet legislated or supported by our courts. It only applies to the provisions of this act and of this agreement. So I don't think there's any harm or any mischief. And as I said, the practice is already there. So I think that answers the points, and I am, as I said, grateful that the point has been elucidated. We'll see what civil society says. You know, the last time I remember the decision taken on the Sexual Offenses and Domestic Violence Act, when those were passed, and there was a big uproar, hue and cry in the country. And, you know, your then leader, Hubert Ingram, did a national address and essentially said to people, get real, you know, just get real. And that was an exercise of leadership in that case. So I would suggest that it's not for me to tell you what to do, but it's my suggestion that this is one of those examples when you are principal and not delegate. And I know you're going to vote against it or stand back from it, but it's my hope that you see it in that light, and that's the way the government argues it. So thank you very much, and I support the bill and so move. Thank you.
Thank you, Honorable Member. As many? Oh, okay. It has been moved and seconded that the following bill be read a second time and committed. A bill for an act to incorporate the agreement granting legal status to the international development law organizations into the laws of the Bahamas for connected purposes. As many as are in favor will remain seated. Those opposed will stand. Order that the bill be read a second time and committed.
A bill for an act to incorporate the agreement granting legal status through the International Development Law Organization into the laws of the Bahamas and for connected purposes.
Further second readings. The chair recognizes the honorable member for Golden Gates.
Mr. Deputy, I move that the House do now resolve itself into the Committee of the Whole House.
Is there a seconder?
With
Seabreeze?
seconder. No further second reading. For, pardon me? Yeah, with the member for Seabreeze in the chair.
It has been moved and seconded that the House do now dissolve itself into the Committee of the Whole with the member of Seabreeze in the chair. As many as are in favor will remain seated. Those opposed will stand. The motion is carried. The House will now resolve itself into the Committee of the Whole with the member of Seabreeze in the chair. Honorable members,
Committee of the Whole.
Madam Speaker. Okay. Madam Speaker, I move that the long title of the Immigration Amendment Bill be agreed.
It has been moved and seconded that the long title of the bill be agreed. As many as are in favor will remain seated. Those who are opposed will stand.
It's immigration, right?
Yeah. It's immigration.
It's immigration.
Immigration?
Bill.
Yeah, immigration. Okay.
No, that was this on immigration bill.
So we, okay.
The long title is agreed.
Madam Speaker, I move that the short title of the bill be agreed.
Is there a seconder? It has been moved and seconded that the short title of the bill be agreed. As many as are in favor will remain seated. Those opposed will stand.
Madam Speaker, I move that clauses 1 and 2 of the bill be agreed.
It has been moved and seconded that clauses 1 and clause 2 be agreed. As many as are in favor will remain seated. Those opposed will stand. The motion is carried.
Madam Speaker, I move that the bill in its entirety be agreed.
It has been moved and seconded that the bill in its entirety be approved. As many as are in favor will remain seated. Those who are opposed will stand. The bill is agreed in its entirety.
Madam Speaker, I do agree that the long title of the bill, International Development Law Organization Bill 2024, be agreed.
It has been moved and seconded that the long title of the bill be agreed. As many as are in favor will remain seated. Those who are opposed will stand. The long title is agreed.
Madam Chair, I move that the short title of the bill be agreed.
It has been moved and seconded that the short title of the bill be agreed. As many as are in favor will remain seated. Those opposed will stand. The motion is carried. The short title is agreed.
Madam Chair, I move that clauses 1 through 5 of the bill be agreed.
It has been moved and seconded that clause 1 through 5 of the bill be agreed. As many as are in favor will remain seated. Those opposed will stand. The motion is carried.
Madam Chair, I move that the schedule of the bill be agreed.
It has been moved and seconded that the schedule of the bill be agreed. As many as are in favor will remain seated. Those opposed will stand. The motion is carried. The schedule of the bill is agreed.
Madam Chair, I move that the bill in its entirety be agreed.
It has been moved and seconded that the bill in its entirety be approved. As many as are in favor will remain seated. Those opposed will stand. The bill is agreed in its entirety.
Madam Chair, I now move that the Deputy Speaker do take the chair.
Is there a seconder? Seconded. It has been moved and seconded that the Deputy Speaker do now take the chair. As many as are in favor will remain seated. Those opposed will stand. The motion is carried. The Deputy Speaker will now take the chair.
third reading and passing of bills.
Mr. Deputy, I move for the third reading and passing of the following bills. Immigration Amendment Bill 2024.
Is there a seconder? Seconded. It has been moved and seconded that the following bill be read a third time and passed. A bill for an act to incorporate the agreement granting legal status to the International Development.
Immigration
that's
Amendment.
immigration?
Immigration
Oh, my
Amendment.
apologies. A bill for an act to amend the Immigration Act. As many as are in favor will remain seated. Those opposed will stand. Order that the bill be read a third time and pass.
A bill for an act to amend the Immigration Act.
A bill for an act, order that this bill do now pass, and the title therefore to be, a bill for an act to amend the Immigration Act. Further third reading of bills.
Mr. Deputy, I move for the third reading and passing of the following bill. International Development Law Organization Bill 2024.
It has been moved and seconded that the following bill be read a third time and pass. A bill for an act to incorporate the agreement granting legal status to the International Development Law Organization into the laws of the Bahamas for connected purposes. As many as are in favor will remain seated. Those opposed will stand. Order that the bill be read a third time and pass.
A bill for an act to incorporate the agreement granting legal status to the International Development Law Organization into the laws of the Bahamas and for connected purposes.
Order that this bill do now pass, and the title therefore to be, a bill for an act to incorporate the agreement granting legal status to the International Development Law Organization into the laws of the Bahamas for connected purposes. Further third reading of bills.
No further third readings, Mr.
Thank you,
Deputy.
Honorable Member. Moving down the agenda. Consideration of Senate amendments. Resolutions. Member statements. The chair recognizes the honorable member for Fox Hill.
Mr. Deputy, I just wanted to take this opportunity to thank the Member of Parliament for Exuma and Ragged Island for an extraordinary last 4 days in what is one of the most captivating islands and capital cities in our country. It has been, I guess, since 1978 that I was first introduced to what was then called the Exuma Regatta, and later became the Family Island Regatta, and is now the National Regatta. And it has grown bigger and better every year. What is interesting to me is the economic impact of the spread of our culture throughout the country, and how the people of Exuma have adjusted to the influx of visitors who come every year and have a good time. It was a good time, a safe time for family enjoyment, and the boat racing was a bonus.
He conspired against me to keep his trophy.
So was it on Friday, the Prime Minister came armed in his short pants
Ready to race.
with every intention of joining the race. But little did he know that his deputy had spoken to the man upstairs and fixed the weather. But what was interesting, since I found that out, though, we had postponed the Lenten tea in my constituency to yesterday. And for a time there, it looked as if the weather was going to be bad and we would not be able to have our function outside. But I assured them that I knew the Member of Parliament for Exuma and Ragged Island, and he had connections with the man upstairs. So I called him, and all was well with the weather in Fox Hill yesterday. So everything works out. But I do also want to thank those ladies and gentlemen who prepared a wonderful event yesterday a very fine tradition, which we've been doing in Foxville since 1998 in my association with that constituency. I want to thank them all for it, and I look forward to meeting everybody next year. But congratulations to the people of Exuma again, and again to my colleagues in Foxville for a great event. Well, you know, the fix was in. The fix was in.
Me sailing on Friday.
So the reigning and still champion for the next year. Yes, 2 times in a row.
Next year.
One time by default. But thank you and congratulations to all of you.
Thank you, Honorable Member.
Next year, it will be sunny.
Appointments of select committees. Instructions of select committees. Discharge of select committees. Notices for future meetings.
The name of the government.
The chair recognizes St. Anne's.
I rise to renew all notices in the name of the opposition, Deputy Speaker.
Thank you, Honorable Member. Adjournment.
So Deputy, I move that the House do adjourn to Wednesday, May 1st at 10 a.m. Second.
It has been moved and seconded that the House do not, in its arising, do adjourn to May 1st, 2024 at 10 a.m. As many as are in favor will remain seated. Those opposed will stand. Final adjournment.
Final adjournment. This Deputy. The House, I move now that the House do adjourn.
Is there a seconder? Seconded. It has been moved and seconded that the House do not join. As many as are in favor will remain seated. Those opposed will stand. The House do now stands adjourned to April the 1st, May the 1st, my apologies, May the 1st, 2024 at 10 a.m.
All right.